Hello, good evening, and welcome to Unacademy, a one-stop destination for the English medium civil services aspirants. Welcome to a marathon session on Indian polity for Prelims 2024. In this live class, we shall discuss lots and lots of MCQs and the concepts related to these MCQs, which I hope will help you answer all questions that will be asked in the upcoming prelims examination. So please stay with me till the end. I'm sure by attending this lecture in full, you would be able to revise a significant portion of your polity syllabus. But before we start, I urge you to press the like button and subscribe to our channel if you haven't yet. Let's get started quickly and look at question number 1 and answer this. Which of the following statement is correct regarding parliamentary democracy? In a parliamentary democracy, the executive branch derives its legitimacy from the directly elected president. But in a parliamentary democracy, president is not the power holder. So this statement becomes incorrect. Parliamentary democracy entails a fusion of powers where the executive branch is drawn from the legislature and is accountable to it, blurring the distinction between the two. Let's wait. Statement 3, the hallmark of parliamentary democracy lies in a system where the executive and legislative branches operate independently, ensuring checks and balances. But this is a feature that we find in a presidential form of democracy, not in a parliamentary form of democracy. Parliamentary democracy is characterized by a strong separation of powers, with the executive branch holding supreme authority over the legislature, ensuring swift decision making. Again, this is something that we see in a presidential form of democracy. Parliamentary form of democracy in India means that Prime Minister and his Council of Ministers, they are accountable to Lok Sabha, the lower house of Indian Parliament, which means the executive is accountable to legislature. And in a parliamentary form of democracy, such as we see in India or Britain, there is no strict separation of powers between the executive and the legislature. In fact, executive is drawn from the legislature. That is what we call blurring the distinction between the two. So it is B. B is the right answer for parliamentary democracy. Even the Constitution does not talk about separation of powers between the executive and the legislature. Our Constitution talks about separation of powers between the executive and the judiciary. And that is mentioned under Directive Principles of State Policy. That's under Article 50 of the Constitution. Clear? Let's look at question number 2. Which of the following statements best describes a characteristic of a totalitarian regime? A form of government which ensures and exacts and exerts tremendous power and control over the people. That's what we call a totalitarian regime. So closely it mirrors a dictatorial form of government. Totalitarian regimes encourage freedom of speech and expression and independent media. They don't, because they want to exert control over everything, even on the media. So they want media to parrot the words or the lies of the government. So this can't be the correct answer. In totalitarian regimes, political opposition is tolerated and often encouraged. They don't tolerate dissent, which is the hallmark of the opposition. So this cannot be true either. Totalitarian regimes exert extensive control over all aspects of citizens' lives, including political, social, and cultural activities. This seems correct, but we'll have to read all the 4 statements. Totalitarian regimes prioritize decentralization of power, ensuring checks and balances within government institutions. This becomes a democratic government. This becomes a federal government which ensures there is decentralization of power. So what is the right answer? C is the correct answer. Clear? Let's look at question number 3. In the context of judicial review, which of the following best describes the concept of judicial restraint? judicial review, which basically means the power of the judiciary, that what it does, it reviews. What does it review? The acts of legislature, and the actions of the executive as well, to check whether the laws passed by the legislature are in agreement with the Constitution or not, whether the actions of the executive, the rules enacted by the executive, whether they are in conformity with the idea of Constitution or not. That's what we call judicial review. But this concept of judicial review, we have discussed this previously, is not explicitly mentioned in the Constitution. So nowhere in the Constitution does Constitution talk about the power of the judiciary known as judicial review. But we can trace this concept of judicial review by looking at Article 13 of the Constitution, by looking at Article 32 of the Constitution, by looking at Article 226 of the Constitution. So you can start the poll and let's see whether the students are able to answer this question or not. Judicial review is not mentioned in the Constitution, but we can trace it. For example, Article 13 says, the state shall not enact any law to delete, abridge a fundamental right. And then if such an abridgment takes place, then that law shall be declared unconstitutional. So the assumption is, who will declare that law unconstitutional? Judiciary. Similarly, your fundamental rights are getting violated. You can directly approach the Supreme Court under Article 32 of the Constitution. If the state is violating your fundamental rights, and the courts then become the protector of your fundamental rights, Supreme Court specifically. This is where we can trace the concept of judicial review. Article 226, where you can approach a high court as well in case your fundamental rights have been violated. That's what we call judicial review. But there are related concepts. Judicial restraint. Restraint is you are exercising restraint. Restraint in the sense you are very eager. Sir, please shift to the next question. I know the answer to this question. So you are in a hurry. That's what we call you are not restrained. But what if you will restrain yourself, let the teacher discuss this entire question, then automatically we have to jump to the other question. So you are exercising restraint. Judiciary, if it's exercising restraint, that means it will not be too quick or too in a hurry to declare the laws passed by the Parliament as unconstitutional, unless and until that law is blatantly unconstitutional. That's what we discussed previously, presumption of constitutionality. Laws passed by the Parliament, if they are challenged before the courts will assume that the law is constitutional. It is for the petitioner to prove that this law is unconstitutional. So that is judicial restraint. But then we have judicial activism, where the judiciary is too eager to strike down a law, where the judiciary is too eager to give justice to the people in case other branches of the government, they are unwilling to do that or they are not in a capacity to do that. That's what we call judicial activism. Then there is a concept called judicial evasion, where there are politically sensitive matters. The judiciary is not hearing these matters and thereby it is siding with the government. For example, electoral bonds passed in 2017, implemented in 2017, but then we saw in 2024, finally after so many years, the Supreme Court declared it unconstitutional. So that's what we call judicial evasion. What is this judicial restraint? Judicial restraint refers to the tendency of judges to defer to legislative and executive decisions without questioning their constitutionality. Maybe. Judicial restraint signifies the proactive role of judiciary in aggressively reviewing all legislative and executive actions for constitutionality. This is what we call activism, not judicial restraint. Judicial restraint denotes the practice of judges refraining from involving themselves in political matters, thereby limiting their scope of judicial review. This is what we can call judicial evasion. Judicial restraint is synonymous with judicial activism. That's clearly not true. So what is the right answer? judicial restraint. A is the right answer. Clear? Very good. Question number 4. Let's start the poll. Which of the following is or are an example or examples of judicial overreach, where the judiciary is somehow violating the separation of powers, encroaching into the domain of the executive, encroaching into the domain of the legislature, so doing what legislature should have to do, what executive had to do, that judiciary is doing. That's what we call judicial overreach. So there is a thin line between judicial activism and judicial overreach. If it is judicial overreach, it violates another basic structure of Indian Constitution, which is theory of separation of powers. Now look at these statements and let's start the poll. Let's look at how many students are able to answer this correctly. And I won't discuss this question unless and until you have some time. So 1 minute for you. Please let me know what is the right answer. More seconds. C is the right answer. Now listen to me carefully. Statement number 1, Supreme Court invoking Article 142 and Supreme Court by invoking Article 142 can issue any order so as to give complete justice. Supreme Court invoking Article 142 to remove a minister from his post who has violated 10th schedule. That means he should have been disqualified under anti-defection law, but no action was taken against him by the Speaker. So what will Supreme Court do? When the matter reaches the court, and this is what has happened in case of Manipur, where a 2-judge bench of the Supreme Court invoked Article 142 and removed a minister from his post because that minister had defected, violated 10th schedule of the Indian Constitution, and no action was taken by the Speaker. So the clear example is given. This is not an example of judicial overreach. This is judicial activism. Because judiciary is not violating any law here. It's invoking Article 142. So this is incorrect. All the other statements are correct. Why? You're confused now. Judiciary directing the government to alter a governmental policy. Policy making is the job of the executive. And if the judiciary is directing the government to alter a government policy, for example, 122 2G licenses were cancelled. And then the Supreme Court asked the government that whenever tomorrow you have to auction a resource, whenever you have to give the resources, you need to auction those resources. And now the government has filed a petition before the Supreme Court asking the Supreme Court that you should reconsider that judgment. So directing the government to alter the policy, which is the job of the executive, you are violating separation of powers, which is judicial overreach. So this is correct. Supreme Court declaring the winner of a mayoral election. This is where you may be in a confused state of mind. If this statement was qualified with the context, saying mayoral election results was declared by the Supreme Court in case of Chandigarh because the returning officer made some errors. The returning officer was biased in favor of a particular political party. But that context is not given. It's only a half statement. Judiciary declaring the winner in a mayoral election, which is the job of the Election Commission, or which is the job of the State Election Commission, or which is the job of the other organs of the state. That is a classic example of judicial overreach. Supreme Court directing linking of rivers to aid states facing water shortage. This again falls within the domain of policy making. And policy making, my dear, is the job of the executive. And if you're encroaching into the domain of the executive, if you're encroaching into the domain of the legislature, that is what we call judicial overreach. So this statement is also correct. So which leaves us with C, 3 is the right answer. Clear? In statement 1, that's the job of the speaker, but the speaker is not taking any action. And ultimately, Supreme Court has to do complete justice in this case. So this is activism, not overreach. Let's look at question number 5. Which of the following is a fundamental characteristic of free and fair election? And listen to me carefully. Let's start the poll. Free and fair election generally, not specifically to free and fair election in India. So we are talking about a general concept of free and fair election. What is a free election? Anybody who is eligible to contest election is allowed to contest election. So it's free. Everybody is allowed to campaign for the elections. Everybody is in a position to organize rallies and propaganda to win votes from the people. That's a fair election. But what if election is fair, but it's not fair? Election is free, but it's not fair. Fair in the sense, people have voted, but all votes went to one political party. So you are convoluting the system in such a manner that the entire election process is biased in favor of one political party or one coalition. So it's not a fair election. Complete absence of any form of campaign financing, where corporates, people donate money to political parties. Can we say if that is completely eradicated, no political party receives funding, how is that free and fair election? So eradication or complete absence of any form of campaign financing, that's not a fundamental characteristic of free and fair election. Incorrect. Strict enforcement of Model Code of Conduct. Model Code of Conduct is peculiar to India, where the very purpose of Model Code of Conduct is to ensure a level playing field. So if you are asked what is the objective of the Model Code of Conduct, the very objective of Model Code of Conduct is to ensure level playing field so that all political parties or candidates, they have equal chance of winning the election. But that's a feature in India. We are talking about which of the following is a fundamental characteristic of free and fair election. If it was free and fair election in India, then this statement becomes correct. Equal access to electoral process for all eligible citizens without discrimination. If you are eligible, you are not being discriminated against, you have access to the electoral process, you want to contest election, that is the characteristic feature of free and fair election. Gerrymandering. What is gerrymandering? The political party in power redrawing the electoral constituencies or boundaries in such a manner that it favors the ruling political party. Which means if there are 3 constituencies and in 2 constituencies the government is strong, one constituency the government is not strong, the ruling political party is not strong. So what you do, you split that constituency, you merge it with other constituencies so that you split the voters. That's what we call gerrymandering. That is not a characteristic of free and fair election. That makes the entire election process unfair. So what is the right answer here? Right answer is A. But if it is free and fair election in India, then you can say 2 statements are correct. Is that clear? Let's look at question number 6. What is the essence of freedom in a democratic society? Let's start the poll. We have discussed these questions on the platform, on Unacademy app, but we received a lot of comments from the students, mails, that we are unable to access those classes. So all those important questions from that static portion we shall be covering here. If you have already attended those lectures, here is a revision for you. If you haven't, stay. absolute autonomy without any constraints or responsibilities. So you have the absolute autonomy, but what about others? You are encroaching into their domain. You are violating their freedom as well. That cannot be the characteristic in a democratic society. Unrestricted ability to infringe upon the rights and freedoms of others. That is freedom, but not democracy. The presence of laws and regulations ensuring the protection of individual liberties. We have laws. We have the supreme law of land, which is the Constitution. And in that supreme law of land, we have part 3 of the Constitution, which is fundamental rights. These fundamental rights state cannot violate. So the very presence of laws and their strict enforcement, through these laws you have freedom. So presence of laws is important characteristic for a freedom in a democratic society. The imposition of strict governmental control to maintain order and stability, but that's for a totalitarian regime, that's for a dictatorial regime. That's not the feature of a democratic society. Clear? Very good. Let's look at question number 7. Which of the following statements regarding the preamble is or are correct? There are 4 things that preamble to Indian Constitution tells us. It's like the preface of the Constitution. It's like the identity card of the Constitution. Preamble tells us what is the source of authority of the Constitution. We, the people of India. That means the first thing that preamble tells us is the source of authority of the Constitution. From where does the Constitution derive its authority? Second, it talks about the nature of the Indian state. And what is the nature of the Indian state? Sovereign, socialist, secular, democratic, republic. And all these terms are not separated by a comma. So you will see sovereign, socialist, secular, democratic, republic without a comma separating one from the other. And all of them are in capital letters, which means together it is a composite term. Clear? That's second thing that preamble tells us. Third, it tells us what is the objective of the Constitution. Justice, liberty, equality, fraternity, dignity of an individual, unity and integrity. And it talks about the date on which the Constitution was adopted. We have adopted this Constitution on the 26th of November 1949. That's what preamble tells us. So it sets out the aims and aspirations of the people of India. This is correct. It represents the values that are incorporated in the Constitution. That's also correct. It was adopted by the Constituent Assembly after the draft Constitution had been approved. All these statements are correct. This preamble is based on Objectives Resolution. Objectives Resolution was introduced by Pandit Nehru in the Constituent Assembly, and it was adopted by the Constituent Assembly on 22nd of January 1947. So if preamble is based on the Objectives Resolution, which was adopted in 1947, then how is that this preamble was adopted after the draft Constitution had been approved? It's because Objectives Resolution was adopted first. Preamble is based on Objectives Resolution, but preamble was the last item to be voted upon in the Constituent Assembly to ensure that all other parts, all other articles of the Constitution, they are not in conflict with the preamble, because preamble is the identity card of the Constitution. It's like the philosophy of the Constitution. So C is the right answer. Question number 8. Which of the following statements is or are correct? Indian Parliament is sovereign. Indian Constitution is federal only because of the judicial interpretation. Let me know what is the right answer. Indian Parliament is sovereign. Indian Parliament is not sovereign. Sovereign means Indian Parliament can do anything. We say the UK Parliament is sovereign because there is no limitation on the powers of the UK Parliament. Indian Parliament has limitation. It cannot violate basic structure of the Constitution. It cannot violate the Constitution. Indian Constitution is federal only because of the judicial interpretation. This is also incorrect, so D is the right answer. Indian Constitution is federal. Even then, Article 1, Clause 1 of the Constitution says, India, that is Bharat, shall be a union of states. So does that mean Indian Constitution refers to itself as unitary? No. Dr. Ambedkar said, our Constitution is federal. But I have used the term union of states and not federation of states because of two reasons. One, India is not the result of an agreement between states. Unlike United States of America, there were 13 British colonies in Northern America. They revolted and then they liberated themselves. Now these 13 independent states, they decided to come together and create United States of America. That's how they met at Philadelphia and wrote and drafted their constitution. So United States of America was created because there was an agreement, because there was a treaty amongst the states. That's not how India was created. India was already there. But sir, princely states also joined India. But princely states did not have a treaty basis that India was created. India was already there. Second, no state in India has the right to secede, to come out of the Union of India. That is why Dr. Ambedkar said we have used the term Union of States and not Federation of States. But even then, India is federal. Why? Because of various accidents. One such accident is the judicial interpretation. For example, in 1994, S.R. Bommai judgment, Supreme Court said federalism is part of the basic structure of Indian Constitution, where a case involving the misuse of Article 356 was to be heard by the court. And the Constitution bench of the Supreme Court said federalism is part of the basic structure. But it's not only because of judicial interpretation. Our polity is federal because Dr. Ambedkar said it is federal. Our polity is federal because what we saw linguistic federalism in India, where the states were created in India in the name of language. 73rd and 74th Amendment, that is what created a federal constitution. Because what is federalism? Where there is distribution of powers between two or more layers of the government. We have center, we have states, we have urban local bodies and rural local bodies, Panchayati Raj institutions. So we have federalism in India because of various reasons, various accidents. Because of the 1991 economic reforms, we are federal. So not only because of the judicial interpretation, that is why D is the right answer. Question number 9. When there are in a law two provisions which are in conflict with each other, that both of them cannot stand, they should, if possible, be so interpreted that effect can be given to both. This rule is known as A, B, C, D. What is it? Priya Kumari is right. It is Doctrine of Harmonious Construction. But this was basically propounded in a case known as Golak Nath versus State of Punjab, 1967. Harmonious construction. For example, you try to give effect to a law. Let's say you want to give effect to a directive principle of state policy. But in the process, fundamental rights are violated. What will happen to this law? or there are in this law multiple provisions and some of these provisions conflict with each other. Doctrine of Harmonious Construction says, give effect to both. Unless and until that is completely not possible, then give effect to only one. But as much as possible, you should try to give effect to both these provisions so that they are not in conflict with each other. That's what we call harmonious construction. In Minerva Mills case, the Supreme Court in 1980 said, balance between fundamental rights and directive principles of state policy, it is also part of the basic structure of Indian Constitution. Minerva Mills, 1980. And in fact, it was in this case also that Supreme Court said judicial review is also part of the basic structure of the Constitution. Clear? Okay. Question number 10. Which of the following can be viewed as centralizing feature or features of Indian federalism? Article 3, Part 2, Part 4, Emergency Provisions, Procedure for Amendment of the Constitution. What is the right answer? In Kyoto Holohan case, the Supreme Court said, again, judicial review is part of the basic structure because it was meant to review 10th schedule of the Constitution, where originally it was said that this decision of the Speaker shall be final and binding. Supreme Court said it can't be final and binding because judicial review is part of the basic structure. Under Article 3, who has the power to reorganize states in India? Parliament. And what is this Article 3 can be asked in your examination. Under Article 3, Parliament has the power to increase the area of a state, decrease the area of a state, alter the boundaries of the state, change the name of a state, merge two or more states. That's the power available with the Parliament under Article 3. But under Article 3, a consultative process needs to be followed. And what is that consultative process? This bill to reorganize a state, whether merge states or split states, this cannot be introduced in the Parliament by the government unless and until it is approved or prior consent is given by the President of India. But before President can give his consent that yes, this particular bill can be introduced in the Parliament, President refers this bill to the legislature of that state which is going to be affected by this bill. So if you want to split Uttar Pradesh and you want to introduce a reorganization bill in Parliament, you cannot do that. The government cannot do that without prior consent of the President. And the President, before giving her consent, will have to refer this bill to Uttar Pradesh Assembly. Only when Uttar Pradesh Assembly gives its views, then you can introduce this bill in the Parliament. But these views are not binding on the President. Even if the Uttar Pradesh legislature rejects this bill, in its view say we don't want bifurcation, we don't want trifurcation, even then the President can give his approval, the bill is introduced in the Parliament, and this bill can be introduced in either of the two houses. First in Lok Sabha, then Rajya Sabha, or first in Rajya Sabha, then in Lok Sabha. And this bill requires simple majority. So states have no role in their reorganization. And that is one centralizing feature of Indian federalism. We are federal, but there are some provisions of the Constitution which are biased in favor of a strong center. And that is what we call, we are a quasi-federal polity. Part 2 of the Constitution deals with citizenship. There is only one citizenship. You are only the citizen of India. States cannot have their own citizenship laws. And citizenship is a central subject, union list. So that is also correct. Unlike United States where they have dual citizenship. You are a citizen of US, you are the citizen of Chicago, Michigan, Illinois, so on and so forth. Part 4 of the Constitution deals with directive principles of state policy. And recently, Uttarakhand legislature enacted a law which tries to give effect to Uniform Civil Code in Uttarakhand, which means who can give effect to the provisions under Part 4 of the Constitution, directive principles of state policy, both center as well as states. So that is not centralizing feature. That is true feature of federalism. Incorrect. Emergency provisions, Article 352, 356, 360, which in a sense converts our Indian Constitution from federal to unitary for some time when there is a grave danger to India. That is a centralizing feature. Procedure for amendment of the Constitution, we cannot say entirely. Why? 1, 2, 4, C is the right answer. Why? Because there are some provisions of Indian Constitution. If they are federal features, they cannot be amended by the Parliament alone. Parliament then would have to refer this constitutional amendment bill to all the state legislatures. And only when at least half of the state legislatures approve, only then the Constitution is amended. And these states will have to pass a resolution to approve this constitutional amendment bill. And that resolution should be passed by what type of majority? Anyone? Simple majority. Question number 10 done. Let's look at question number 11. There is nothing in the Constitution which would entitle a new state after its formation or admission into union to claim complete equality of status with an existing state. Daman and Diu, Dadra and Nagar Haveli, Goa, Sikkim, Pondicherry, which is now Puducherry, have been admitted into the Union of India by invoking Article 2 of the Constitution. Which of these statements are correct? Let me know what is the right answer. Thirty more seconds. There is nothing in the Constitution which would entitle a new state after its formation or admission into union to claim complete equality of status with an existing state. This is correct. Why? That deals with Article 2 of the Constitution. Parliament may, by law, what Parliament can do, it can enact a law, and through this law, it can admit into India or establish new states on such terms and conditions as it deems fit. And the explanation to that is, the Parliament can also alter Schedule 7 for such states. For example, a state is admitted into union or a new state is established. For example, a union territory is converted to a state under Article 2 of the Constitution. That new state which is created, it cannot claim complete equality with existing states, saying existing states and us should be treated equally. That means all the items in the 7th schedule related to list 2 or state list should be given to that state. No. Daman and Diu, Dadra and Nagar Haveli, all these were admitted into union by invoking Article 2. It is incorrect. Why? Because all of them were admitted into India by invoking constitutional amendment, Article 368 of the Constitution. The only territory that we can say was admitted into India through Article 2, that is Chandar Nagore. So which of the statements are correct? A, only one is the right answer. Sikkim was also admitted via Article 368 by 35th Constitutional Amendment Act. Yes, that is an example of asymmetrical constitution. Question 12. According to the Constitution, when there is a vacancy in the office of the President and the Vice President, then the Chief Justice of India shall act as the President of India. Justice Hidayatullah is the only citizen in independent India to have held positions of Chief Justice, Vice President and Acting President of India. President is elected by an electoral college consisting of elected members of both Houses of Parliament and state legislative assemblies. Which of these statements is or are correct? Question number 12, let me know what is the right answer. For Delhi, 3 subjects are kept with the union related to law and order, land, police, because Delhi is the capital. It's not a normal state. According to Constitution, when there is a vacancy in the office of President and Vice President, then the Chief Justice shall act as the President of India. This statement is incorrect. Because Constitution originally said, if there is a vacancy in the office of President, then Vice President shall act as the President of India. What if there is vacancy in the office of Vice President as well? The Constitution is silent there. That is why in 1970, a law was passed known as President Discharge of Functions Act. And it is this law which says if there is a vacancy in the office of the President as well as the Vice President, then the Chief Justice of India will act as the President of India. In absence of Chief Justice, senior most judge of the Supreme Court shall act as the President of India. So this is not according to the Constitution, this is a statutory provision. Covered under President Discharge of Functions Act. The remaining 2 statements are correct. President is elected by an electoral college consisting of elected members of both Houses of Parliament and state legislative assemblies. Now you will say, sir, Union Territories is not mentioned, Delhi and Puducherry is not mentioned, so that means statement 3 is incorrect. No. If it would have been mentioned, President is elected by an electoral college consisting of only elected members of state assemblies and parliament, then that statement would have been incorrect. Only is not mentioned, that is why C, 2 and 3 is the right answer. Let's look at question number 13. Appointing a Prime Minister can be viewed as a discretionary power of the President. Pardoning a convict is a discretionary power of the President. President can promulgate an ordinance only on the advice of the Cabinet. What is the right answer? Appointing a Prime Minister can be viewed as the discretionary power of the President. Yes, because Constitution says Prime Minister is appointed by the President. That's it. It doesn't say who this Prime Minister can be. It doesn't say that this Prime Minister has to be necessarily the leader of the party which has won the election or which has got the highest number of seats. So this is where, in case, this is what we call situational discretion. If there is a situation where no political party has the majority, the President can appoint anyone as the Prime Minister and then ask that Prime Minister to prove your majority on the floor of the Lok Sabha. pardoning a convict is the discretionary power of the president. This is incorrect. That power under Article 72, the president can exercise only on the advice of the government. And this decision is communicated to the government, communicated to the president by the Minister of Home Affairs. So whenever president receives a mercy petition, this mercy petition is transmitted to the government. So the president is asking the government, the cabinet, what is your advice? Should I reject or accept this mercy petition? And this decision of the cabinet is conveyed to the president by the Home Minister. President can promulgate an ordinance under Article 123 of the Constitution only on the advice of the cabinet. This is correct. So which of these statements are correct? B, 1 and 3 is the right answer. Sir, can governor pardon a death sentence? Can governor pardon a death sentence? No, no, everybody says no. The governor cannot pardon a death sentence. The governor can commute a death sentence. But there were few news stories which said the governor can now pardon a death sentence. That is a misleading article. Why? Because matter reached the Supreme Court. And what was the matter? Previously under Criminal Procedure Code, if you have been convicted for a crime for which the punishment could have been death penalty. For example, you committed murder for which the punishment can be death penalty, but death sentence was not given to you. You were given life imprisonment. According to Criminal Procedure Code, your sentence could have been remitted. That means your sentence could have been reduced, or you could have been acquitted, or you could have been pardoned only after completing 14 years in jail. But then the Supreme Court said, no, the pardoning power of the governor under Article 172 can come into picture at any point in time. So this individual who has been convicted for a crime for which death penalty was an option, but he was given life imprisonment, this convict need not spend 14 years, after which the governor can pardon, or the governor can commute his sentence, or the governor can remit his sentence. No. At any point in time, the governor's pardoning power can be invoked. Clear? Question number 14. The oath or affirmation by the president is mentioned in the third schedule of the Constitution. If a motion calling for the impeachment of the president is moved in a house, the same shall also investigate the charges against the president. If both houses of parliament pass a resolution approving impeachment of the president, then the president stands impeached at the expiry of the 14 days of the passage of that resolution. Which of these statements is or are correct? The oath or affirmation of the president is mentioned in the third schedule. This is incorrect. Why? Because this is mentioned in the text of the Constitution itself under Article 60. If a motion calling for the impeachment of the president is moved in one house, then the same house will investigate. No. If both houses of the parliament pass a resolution approving impeachment, then you don't have to wait for 14 days. The president is impeached from his office forthwith. None of these statements are correct. Clear? How is the President of India impeached? On what ground is the President of India impeached? The ground mentioned in the Constitution is violation of the Constitution. But this term, violation of the Constitution, is not defined in the Constitution. Let's say this process is initiated against the president in Lok Sabha. Till date, no Indian president has been impeached. What if Lok Sabha wants to, or Parliament wants to impeach the president? this matter can initiate in either Lok Sabha or Rajya Sabha. If it is initiated in Rajya Sabha, 1/4 of the members of Rajya Sabha, they have to write to the chairperson that we want to impeach the president. Chairperson will give 14-day notice to the president. After that notice, there will be discussion, then there will be voting. And once this Rajya Sabha passes a resolution, by what type of majority? Not less than 2/3 of the total strength of the House. Then this matter will go to Lok Sabha. And now this Lok Sabha, this other house, will investigate the charges. What are the charges against the president? How the president has violated the constitution? And then the president will be asked to defend himself, or he can get his lawyer to defend himself. And remember, that lawyer cannot be the Attorney General for India. That has to be someone else. And if Rajya Sabha, Lok Sabha also decides that yes, you have violated the constitution, voting will take place. If Lok Sabha also passes this motion by not less than 2/3 of the total strength of the House, then the president shall be deemed to have been impeached forthwith, immediately. You don't have to wait for 14 days. That 14 day is for a notice. Clear? Okay. Question number 15. Constitution allows the Vice President to act as the President of India only in case of vacancy in the office of the President. According to the Representation of the People Act 1951, for the nomination of a candidate for a Vice President, there must be at least 20 proposers and 20 seconders. The President is bound to accept the resignation of the Vice President. 2/3 of the total is also called as special majority. The procedure is not same for Vice President. Vice President is impeached or removed, because the term impeachment is used only for the President under Article 67 Clause B. And for Vice President, the process has to initiate in Rajya Sabha. But there are no grounds mentioned in the Constitution on the basis of which Vice President can be removed. He can be removed on any ground. And Vice President is removed on the grounds of, these grounds are not mentioned in the Constitution, but Vice President, the process has to initiate in Rajya Sabha, and this resolution should be passed by effective majority. Then this proposal goes to Lok Sabha, and Lok Sabha has to pass this motion by simple majority. And once both houses do that, Vice President is removed from his office. Clear? Constitution allows Vice President to act as the President of India only in case of vacancy. What is vacancy? When the seat goes vacant. And what leads to vacancy? Death. Your polity teacher dies, causes vacancy. Someone else has to be hired to teach polity. Vacancy can be because of resignation. Vacancy can also be because of removal, or in case of president, what we call impeachment. This is what we call vacancy. But what if the president is sick? That does not cause vacancy, because he is still the President of India, just that the president is sick, or the president is on foreign tour. There is no vacancy, but it's just that the president is absent. In that case also, Vice President can act as the President of India. So president, vice president acting as the president of India is not only due to the vacancy. It can be when the president is sick, when the president is on a foreign tour, and the president decides that vice president will act as the president of India. So this is incorrect. According to Representation of the People Act, yes, if you have to elect the president, the law says your nomination should be backed by 50 proposers and 50 seconders. 50 voters, which means 50 members of the Electoral College, has to propose your name. 50 others have to second your name. In case of vice president, it is 20 proposers and 20 seconders. That's true. But that is not mentioned in the Representation of the People Act. Then where is it mentioned? It is mentioned under Presidential and Vice Presidential Elections Act 1952. Clear? So this statement is incorrect. The president is bound to accept the resignation of the vice president. President can resign by submitting his resignation to the vice president. Vice president can resign by submitting the resignation to the president, and it is binding for them to accept each other's resignation. So this statement is correct. So which of the above statements is or are correct? A, only one is the right answer. Clear? Very good. Question number 16. The union ministers hold office during the pleasure of the Prime Minister. There is no provision in the Constitution which makes President answerable to the Parliament for the acts of the government. While in India, the Prime Minister can be a member of either House of Parliament. In England, the Prime Minister shall be a member of the lower house of the British Parliament. Let's start the poll. Doctrine of pleasure. Prime Minister holds office during the pleasure of the President. Council of Ministers hold office during the pleasure of the President. But that's not the personal pleasure of the President. That's the pleasure of the Prime Minister. But we call it doctrine of pleasure. That means as long as President is satisfied with you, you can continue to hold office. And if the moment Prime Minister loses his confidence in you, Prime Minister will advise the President that please dismiss that minister, remove that minister. And that advice is binding on the President. But we say it is the pleasure of the President, exercised through the Prime Minister. So union ministers hold office during the pleasure of the Prime Minister. This is incorrect because you hold office during the pleasure of the President. There is no provision in the Constitution which makes President answerable to the Parliament for the acts of the government. This is correct. Because although all executive powers are vested in the name of the President under Article 53 of the Constitution, but the responsibility is with the ministers. Responsibility is with the Prime Ministers, and that is what we call parliamentary democracy, where Council of Ministers and Prime Minister, they are accountable to Lok Sabha. President cannot be held accountable for the actions of the government. While in India, Prime Minister can be a member of either house of the Parliament, Rajya Sabha, Lok Sabha, but in Britain, the Prime Minister has to be necessarily the member of the House of Commons, not House of Lords. Because Britain, just like in India, we also have bicameral legislature. Clear? So this statement is correct. Which of the above statements is or are correct? B, two statements is the right answer. Can the office of Vice President remain vacant? Yes, it can. Any other questions? Sir, will state like Nagaland also have to pass their law because they have a special status? No, no act of parliament will apply to Nagaland if it deals with the customs of Nagas, if it deals with land of the Nagas, customary practices of Nagas. That has got nothing to do with women's reservation. Can Constitution be amended outside of Article 368? Never. If Vice President post is vacant, whom will the President give his resignation? He will convey it to the Speaker of the Lok Sabha. Let's keep moving with the MCQs. Question number 17. According to Constitution, which of the following is not the duty of the Prime Minister vis-a-vis the President? To communicate to the President all decisions of the Council of Ministers relating to the administration, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council, to communicate to the President any legislative proposal she may call for, to communicate to the President the steps being taken by the Union in case where there is a breakdown of constitutional machinery. Does Constitution define democracy? No, it doesn't. Sir, in case of Vice President, it consists of 20 seconders and 20 proposers, yes, but not according to the Representation of the People Act. For emergency also, President is not answerable. Can ECI revoke star campaigners? Yes. All these are duties mentioned in the Constitution. But this is not the duty mentioned in the Constitution. The question is asking according to the Constitution. So to communicate to President the steps being taken by the Union in a state where there is breakdown of constitutional machinery, that is not the duty of the Prime Minister vis-a-vis the President. So A, only one is the right answer. Related to Article 78 of the Constitution. Question number 18. According to the Constitution, the President appoints the Attorney General for India for a period of 3 years. The remuneration of the Attorney General for India is determined by the Parliament. According to Constitution, the Attorney General for India resigns on the resignation of the Council of Ministers. Which of the statements given above are incorrect? Don't make mistakes. Read the question carefully. One and 3B all. According to Constitution, the President appoints Attorney General for a period of 3 years. This is incorrect. Why? Because the term is not mentioned for the Attorney General. Yes, the President appoints Attorney General, but not the term is not mentioned. Remuneration of the Attorney General is determined by Parliament. No, it is determined by the President of India. So this is also incorrect. According to the Constitution, the Attorney General resigns on the resignation of the Council of Ministers. This is according to the convention. Because since Attorney General is appointed by the ruling party, if there is a change in the government, the Attorney General resigns. But this is not something which is mentioned in the Constitution. So it's not a constitutional requirement. The question is asking which of the given statements are incorrect? D. All these statements are incorrect. D is the right answer. That's why, Tushar, I said, read the statement carefully. Okay? Question number 19. A person elected as a member of the Parliament becomes entitled to immunities and privileges of such membership as soon as the election certificate is issued by the returning officer. During the discussion on President's address, the name of the President cannot be brought into debate by any member of the Parliament. Which of these statements is or are incorrect? A person elected as member of the parliament, these privileges and immunities of member of parliament, they are in the news because of the Sita Soren 2024 judgment. So you are, as the member of the parliament, as the member of the state, entitled for some privileges and immunities. But you can utilize those immunities and privileges after you have taken oath, not after the election certificate is issued by the returning officer. So this is incorrect. During the discussion on the President's address, the name of the President cannot be brought into debate by any member of the Parliament. This is correct. Question is asking which of the statements are incorrect. A, only one is the right answer. What is this President's address? We have seen recently in some opposition ruled states, just like we have President's address at the center, we have the Governor's address in every state, which is a practice that we have borrowed from Britain. Some governors, they are not reading this address or skipping some lines in the address, right? So what is the situation surrounding here? The first session each year, and then after the general election, when 2024 Lok Sabha elections would get over, then we will have new MPs in Lok Sabha. Once their oath ceremony is done, then there will be a President's address. President of India will address both members of both houses of the Parliament together. The speech, the text of the speech will be given by the government, will be given by the cabinet. And the President reads that speech from line 1 to line next, right? It talks about the priorities of the government, the achievements of the government, so on and so forth. That's not only after every general election. Every year, the first session of a year, it is addressed by the governor, it is addressed by the President at the central level. After that President's address or the governor's address, there is discussion on this address, and then there is voting. That is what we call vote of thanks on President's address or vote of thanks on governor's address. If this vote of thanks is defeated in Lok Sabha or defeated in Legislative Assembly, that means it does not obtain simple majority. What will happen to the government? It will be construed that the government has lost confidence. The government will have to resign. That is why this President's address, this governor's address becomes very important. But what if this President's address is defeated in Rajya Sabha or is amended in Rajya Sabha? Nothing will happen to the stability of the government because the Council of Ministers are accountable only to Lok Sabha. They're not accountable to Rajya Sabha. Clear? Is it legally binding on President or Governor? Can he deny reading if it's not fair? The governors have denied although it's a practice that we borrowed from Britain, the Queen used to address. But normally they should not do this, because after all, the real power is with the government, not with the appointed governor. Okay. Question number 20. The President, after receiving the suggestion of the Prime Minister, approves the date for the election of the Speaker of the Lok Sabha. The date for the election of the Deputy Speaker of the Lok Sabha is fixed by the Speaker of the Lok Sabha. 17th Lok Sabha is the only one to not have had a Deputy Speaker for its entire tenure. Which of these statements, A, B, C, D, what's the right answer? When election certificates are issued, if I win the election today, I will get the certificate today. For example, the Surat candidate of the BJP won unopposed. He got the election certificate by the returning officer. Is it mandatory for the Attorney General to resign? No. The President, after receiving the suggestion of the Prime Minister, approves the date for the election of the Speaker of the Lok Sabha. This is correct. The date for the election of the Deputy Speaker of the Lok Sabha is fixed by the Speaker of the Lok Sabha. This is also correct. 17th Lok Sabha is the only one to not have had a Deputy Speaker in its entire tenure. This is also correct. But what's the question asking? Which of these statements is or are incorrect? None of these statements are incorrect, because all the statements are correct. So D is the right answer. Why most of the students are going wrong? That's what happens. Each year, more than 1 million aspirants apply for the civil services exam. Only half of them, they write the exam. And the serious candidates are less than 70,000 or 50,000. That is why this exam is not tough. It's not the most difficult exam, because majority of the aspirants are non-serious. Clear? Missed incorrect, missed incorrect. That is why you should attend these sessions. Take as many mocks as possible, so that you don't make such mistakes in the exam. Okay, let's look at question number 21. Which of the following is responsible for the administration of the Government of India Transaction of Business Rules 1961 and the Government of India Allocation of Business Rules 1961? PMO, Prime Minister's Office, Cabinet Secretariat, Cabinet Committee on Political Affairs, Secretary General of the Lok Sabha. Dixit Goda 8, A. Okay. The answer is the Cabinet Secretariat. And what this Cabinet Secretariat does, it submits monthly reports of activities of ministries, all the departments. Now, monthly report is sent to whom? This becomes important. This monthly report is not only sent to President, it is also sent to Prime Minister. But not only sent to President and the Prime Minister, also sent to the Vice President, who otherwise is not, the poor man is never in the picture. So Vice President as well. And this Cabinet Secretariat it also provides assistance to all cabinet meetings. If you clear this exam and you are allotted IAS, the highest rank that you should aspire for is that of the post of the Cabinet Secretary. But for that, you should qualify this exam at an early age so that you have a long tenure. There is age on your side and you can become the Cabinet Secretary. After that, directly, Prime Minister. Okay. Question 22. The Prime Minister is the chairperson of which of the following funds? PMO is not mentioned in the Constitution. Cabinet Secretariat is not mentioned in the Constitution. Committee of Political Affairs is not mentioned in the Constitution. It is mentioned in the Rules of Business and Procedure. PM Priyanshu Saxena. Priya Kumari is all set to ace prelims. Congratulations. National Defence Fund, it was launched in 1962 to assist the family members of the defense personnel, army, so on and so forth. PM National Relief Fund, 1948, when there was a appeal given by Prime Minister Pandit Nehru that there are migrants coming from Pakistan to India and we need to provide them relief. For them, please donate to Prime Minister's National Relief Fund. PM Cares during COVID-19 pandemic, Compensatory Afforestation Fund Management and Planning Authority. It was directed by the Supreme Court based on Goda Varman judgment of 2002, which was also in the news during this year. But this comes under Ministry of Environment and Forests. And the ministry is known as the Ministry of Environment, Forests and Climate Change. So PM is the chairperson of 1, 2 and 3. 3 is the right answer. Only 3. Clear? And for all these 3 funds, there are no budgetary allocation. That means from the union budget, you don't give money, funds to these 3 funds. They receive funds through voluntary contributions. Clear? And PM Cares, for example, Prime Minister is the ex officio chairperson. Who are the other members? Ex officio members. Anyone? We have the Home Minister and Defense Minister and External Affairs Minister. Rajendra is wrong. It's the Finance Minister. Great. Question 23. The quorum to constitute the sitting of the Lok Sabha is 55 members, excluding the Speaker. While the President has the authority to prorogue the session of the Parliament, the Speaker has the authority to adjourn the House sine die. All the bills pending in the Lok Sabha, except the ones originating in the Rajya Sabha, lapse upon the dissolution of Lok Sabha. Which of these statements is or are correct? I'll give you 1 minute. Let me know what is the right answer. Sir, please explain about constructive motion of no confidence. Mr. Modi is the Prime Minister. I want to introduce no confidence motion. Clear? But if it is constructive motion of no confidence or constructive motion of confidence, in that case, what will happen? I'm not only introducing a motion to defeat the Prime Minister, because Prime Minister does not have the majority, he will have to resign if he does not pass this confidence motion. But I also need to prove that I have the majority. Normally what happens? There's a government in place. You want to remove that government. How? You introduce a no confidence motion. You yourself, you don't have the majority. But you know the government does not have the majority. The government falls. And then fresh election has to take place. In a constructive motion of no confidence, you have to introduce no confidence motion against the Prime Minister. And you also have to introduce some sort of confidence motion saying, I have the majority, he doesn't have the majority, so that there is no need for fresh election. But we don't see that constructive motion of no confidence here. The quorum to constitute the sitting of the Lok Sabha is 55 members, which is 1/10, which is 1 by 543, which is 55. You'll have to round off as well. Not excluding the speaker, including the speaker. So this statement is incorrect. President has the power to prorogue the session. President has the power to summon Parliament, to prorogue the Parliament as well. And who has the power to adjourn the House? Sine die. This is with the presiding officer, the Speaker. All bills pending in the Lok Sabha, except the ones originating in the Rajya Sabha, lapse upon the dissolution of Lok Sabha. Is 3 correct or incorrect? Three is correct or incorrect? Which of the statements given above is or are correct? A, only one is the right answer. Clear? This is where some students make mistakes. When Lok Sabha is dissolved, which are these bills which lapse? 3 kinds of bills. All bills lapse except 3 kinds of bills. Which are these 3 kinds of bills? 1, bills originating in the Rajya Sabha and pending in the Rajya Sabha. That means this bill never saw the light of Lok Sabha. This bill originated in Rajya Sabha, it's pending in Rajya Sabha. Rajya Sabha is the permanent house of Indian Parliament. This bill does not lapse. Clear? But what if there is a bill which originated in Rajya Sabha, was passed in Rajya Sabha, then went to Lok Sabha? This bill lapses upon the dissolution of Lok Sabha. Clear? Second kind of bills which do not lapse, those bills awaiting President's assent. A bill has been passed by both houses of the Parliament. Now this particular bill is waiting for the assent of the President. This does not lapse. Sir, what if President wants to send this bill back, suspensive veto? The President can send this bill back to Rajya Sabha for reconsideration. And the Rajya Sabha is there. Rajya Sabha is the permanent house of Indian Parliament. It is not subject to dissolution. Third, bills on which the President has notified joint sitting. Now you tell me one thing. A bill has originated in the Rajya Sabha, or let's say the bill has originated in Lok Sabha, and now the bill is in Rajya Sabha. Rajya Sabha has rejected this bill. That means on this bill there is a deadlock. What will happen to this bill? Will this bill lapse or will this bill survive? I'll repeat. The bill has originated in Lok Sabha. It was sent to Rajya Sabha. Rajya Sabha rejected this bill. That means there is a deadlock on this bill. That means to resolve the deadlock, we can have a joint sitting. What will happen to this bill? Will this bill lapse or does not lapse? Does not lapse, does not lapse, does not lapse, lapse, survives. Priya Kumari is wrong here. This bill lapses. Unless and until on this bill, because there was a deadlock, if the president would have notified joint sitting, saying on this particular bill we will have a joint sitting, then it will not lapse. It's not that all bills on which there is a deadlock, they survive. No, only those bills where we have a deadlock and the president has notified joint sitting, such bills do not lapse. Clear? And also, there is a motion calling for the removal of judges of High Court or Supreme Court. This motion also does not lapse upon the dissolution of Lok Sabha. What is doctrine of essential religious practice? The Supreme Court in Shirur Math 1954 propounded a doctrine called ERP, Essential Religious Practices, or Doctrine of Essentiality. In a particular religion, there are some essential features, there are some non-essential features. Who will decide what is essential, what is not essential? Judiciary. And what is essential to a religion? Even if it violates fundamental rights, that feature will survive. But if there is a feature in a religion which is non-essential and violates fundamental rights, this feature will not be upheld. This feature will not continue. That is what we call essential religious practices. Okay, I will not go. I will come back to this topic. Question 24. And those of you asking, the time is up. This is a marathon session. Till the time we will complete all the questions that we have selected, we will continue the session. Those who want to go have dinner, please go. Those who want to stay, please stay. Okay? Yes, no, maybe. Okay. Question 24. While the returning officer for the election of the President of India is always the Secretary General of the Lok Sabha, the returning officer for the election of the Vice President is always the Secretary General of the Rajya Sabha. According to parliamentary conventions and traditions, if the Deputy Speaker is also appointed a member of the Parliamentary Committee, he is also appointed its chairman. Authoritarian teacher. This is a totalitarian regime. Sir, you have dinner. I am having dinner right now. This is my dinner. While the returning officer, this is on rotation. So in the 2022 presidential election, Secretary General of Rajya Sabha was the returning officer. In 2027, it will be the Secretary General of Lok Sabha who will be the returning officer. Same with the Vice President's election as well. If 2022 Secretary General of Lok Sabha was the returning officer, in 2027 Vice President's election, it will be the Secretary General of Rajya Sabha who will be the returning officer. That makes statement 1 incorrect. According to parliamentary conventions and traditions, if the Deputy Speaker is also appointed a member of a parliamentary committee, he is also appointed its chairman. This is also correct. So which of these statements are correct? 2B, only 2 is the right answer. Okay. Question 25. The hour before the question hour in both houses of the parliament is known as the 0 hour. During 0 hour, matters are raised by the members without any prior notice or permission. The rule book does not mention 0 hour. The duration of the 0 hour is not specified in any rules. Which of the statements given above is or are incorrect? How many questions did I frame? If I tell you, you will leave. So I'll not tell you. The question, the hour before 0 hour in both houses of the parliament is known as 0 hour. This is incorrect. Because first we have question hour, then we have sometimes 0 hour, and then we have the agenda of the house. Because the 0 hour normally starts at 12 o'clock in the afternoon. That's why the name 0 hour. During 0 hour, matters are raised by members without any prior notice. Correct? Because in question hour, you have to give notice. You can ask questions such as starred question, unstarred question, short duration question. So with notice, you will expect replies from the ministers. But in 0 hour, you can ask questions without any notice. The rule book does not mention 0 hour. Question hour is mentioned in the rules of business and procedure. But 0 hour is not mentioned. In fact, this is an Indian innovation which the practice started in 1962 when there was India-China war in 1962. And when common sense, when rule book, rules of business and procedure does not mention 0 hour, how can it mention what will be the duration of the 0 hour? So sometimes it is 1 hour, sometimes it is 2.5 hours, sometimes it is 15 minutes. So it does not have to be necessarily for an hour, but it is not mentioned in the rule book. So this is also correct. Which of the statements given above are incorrect? A, only one is the right answer. Clear? Question 26. Articles are mentioned and then the scope of that article is mentioned. You will have to tell me which of the pairs are incorrectly matched. This is related to citizenship, so expect a question on citizenship this time. Because the CAA rules have been notified, because the citizenship is in news. But sir, if Prime Minister is also a member of a committee, then he will be the chairperson. Am I right? Roshni, for these parliamentary committees, no minister is appointed. So minister cannot be a member of a parliamentary committee. Yes, what if both speaker and deputy speaker is a member of the committee, then the speaker is the chairperson. Seconds more, you tell me what is the right answer, because you'll have to read a lot. That's why I'm giving you 30 seconds extra. Priya is right. C, 3 pairs. Article 5, it talks about citizenship at the time of the commencement of the Constitution. Which means if you were born on the soil of India and you had stayed in India for 5 years before the commencement of the Constitution, if your parents were the citizens under the Government of India Act 1935, you are the citizen of India. Article 6 and Article 7 have been interchanged. What Article 6 talks about? Rights of citizenship of certain persons who have migrated to India from Pakistan. That means if there are individuals who migrated from Pakistan to India, but they migrated before 19th July 1948, they are the citizens of India. But those who migrated after 19th July 1948, they have to register as the citizens. And the central government will decide whether those persons can become citizens of India or not. Article 7 talks about citizenship status of certain persons who migrated to Pakistan from India. And if you are somebody who migrated from India to what became Pakistan after 1st of March 1947, you are not the citizens of India according to Article 7. Article 8 is correctly matched because it talks about rights of citizenship of certain persons. If you are a citizen of another country, but your parents were the citizens under Government of India Act 1935, you can register to become the citizen of India outside India. Article 9, it basically talks about loss. Loss in the sense, if you have voluntarily acquired the citizenship of another country, then you will lose the citizenship of India. And continuance of the rights of citizenship is mentioned under Article 10, which means whoever is the citizen of India under this Part 2 of the Constitution will continue to remain the citizen of India unless and until Parliament enacts a law. And Parliament enacted this law in 1955 using Article 11, which is what we call the Indian Citizenship Act 1955. Clear? These articles can be important because of the discussions around citizenship. Can a child born on foreign soil have dual citizenship under some conditions? Yes, if the child is born to an Indian parent outside India, then that child can have dual citizenship till the age of 18. And once the child completes 18 years, which means now he is not a child, within 6 months, he or she will have to decide whether you want to retain citizenship of India or you want to continue the citizen of that country. Okay. Question number 27. Trade and commerce in the products of any industry where the control of such industry by the union is declared by Parliament by law to be expedient in public interest is mentioned in Union List under Schedule 7 of the Constitution. The responsibility of agricultural trade and commerce within a state was temporarily entrusted to the Union government for a period of 5 years beginning 1950. What is the right answer? Sir, what about a child born on flight supposed to land in India? If the airspace is India, then the child is an Indian, provided both the parents are Indians or one of the parents is an Indian and the other is not an illegal migrant. Will UPSC ask so minutely about citizenship provisions? UPSC is unpredictable. I don't know. Okay. Trade and commerce in the products of any industry. If the Parliament decides that this particular industry, it is in our national interest that trade and commerce or the products of this industry, it should be kept in the concurrent list. Both Parliament and the state legislature will have the power to make a law, and that is entry 33 of the concurrent list. And this is the provision which was used when 3 farm laws were passed. Clear? So this statement is incorrect because it's not in the union list, it is in the concurrent list. The responsibility of agricultural trade and commerce within a state was temporarily entrusted to the union government for a period of 5 years beginning the Constitution. This is correct. So which of the given statements are incorrect? A, only one is the right answer. This was meant to be temporarily because at the time India became independent, we were poor. Some states were self-sufficient in food, but majority of the states were not. That is why agriculture and responsibility of agricultural trade and commerce, which is normally how the food can be given, that was given to the union government for a period of 5 years. But what was meant to be temporary for 5 years became permanent when Third Constitutional Amendment Act was passed in 1954. So it was originally meant for 5 years, but now it is forever. Responsibility of agricultural trade and commerce. Clear? Question 28. Aligarh Muslim University, on which there is a petition being heard by a 7-judge bench of the Supreme Court, whether it is a minority educational institution and whether it will get protection under Article 30 of the Constitution. Aligarh Muslim University, emoluments of the governors, relief of the disabled and unemployable, because that seems to be the statement in some election manifestos of political parties. We will give relief to unemployable and disabled, taxes on animals, because a lot of stray cattle, it's in the news. Which of the above comes under Union list of Schedule 7 of the Constitution? Ayushi is right. Aligarh Muslim University, yes. Emoluments of the governor. Apart from that, we have Banaras Hindu University, which is also mentioned under Union list. Delhi University. University is under Article 371, capital E. Relief of disabled and unemployable, taxes on animals. This is under state list. So, two options. Question 29. In the context of the census in India, which of the following accurately describes its significance? 4 options. Let me know what is the right answer. Census is primarily conducted for electoral purposes, determining the allocation of parliamentary seats. This is where you might confuse it with delimitation, but that's not the primary purpose of the census. It serves as a tool for tracking demographic changes and planning social welfare programs. This is the right answer, because we get to know whether the people are living in pakka houses or kacha houses, what is the status of the people, how can we create policies and programs for the upliftment of these people. That's the purpose of census. Its purpose is not to collect data related to GDP growth or economic indicators. For that, we have various other surveys. Its main objective is not to monitor and regulate immigration and emigration patterns within the country. That's not covered under census. So B is the right answer. Easy question. Question number 30. Which of the following statements is or are correct? The President can promulgate an ordinance if either one or both houses of the Parliament are adjourned. The Vice President of India can be removed on the grounds of the violation of the Constitution. The Attorney General for India is an integral part of the Union Cabinet. Which of these statements is or are correct? Ayushi is right. Utkarsh is right. Oh, I should not say this. You go on. The President can promulgate an ordinance if either one or both houses of the Parliament are adjourned. If either one or both houses of the Parliament are prorogued. That is the right statement. Because Constitution says the President can promulgate an ordinance if either one or both houses of the Parliament, they are not in session. Adjournment does not terminate the session of the Parliament. Adjournment is only a brief interval in an ongoing session. Sushil says the Vice President, no ground is mentioned for VP removal in the Constitution. So what am I saying? The Vice President of India can be removed on the grounds of violation of the Constitution, correct? If I would have mentioned according to the Constitution, the Vice President is removed on the grounds of violation of the Constitution, then it is wrong. But no grounds are mentioned. So Vice President can be removed on any ground. Misbehavior, corruption, harassment, violation of the Constitution, any ground. Can. So this word can makes it correct. Attorney General is an integral part of Union Cabinet. Integral part of Union Executive. So Union Executive consists of President, Vice President, Prime Minister, Council of Ministers, and the Attorney General for India. So which of these statements are correct? A, only one statement is correct. A is the right answer. This is fraud. Go and fight against UPSC. They don't even release the keys nowadays. Why polity is so interesting? Because I get to teach you. What circumstances trigger the declaration of a financial emergency under the Indian Constitution? A, B, C, D. This is the simplest of all questions if you would have read Article 360 of the Constitution. Under Article 360 of the Constitution, if the President is satisfied when there is a grave danger to the stability, financial stability and credit system of India, then he can proclaim financial emergency. So C is the right answer. Can anybody tell me what is the difference in terms of validity of financial emergency and compared to President's rule and national emergency? Anybody? What is the difference? 2 months, 2 months. National emergency, if it is proclaimed today by the President, it has to be approved by both houses of Parliament by special majority within 30 days, within 1 month. President's rule, if it is proclaimed today, it has to be approved by both houses of the Parliament within 2 months by simple majority. Same goes with financial emergency as well. It has to be approved by both houses of the Parliament by simple majority within 2 months, within 60 days. But national emergency, there is a limit. National emergency can continue only for 6 months. Then resolution has to be passed again to extend national emergency for another 6 months. So national emergency can be extended multiple times in number of years, but only 6 months at a time. That's what we call periodic parliamentary control. Unless and until Parliament approves, you cannot continue national emergency for a further period of 6 months. In case of President's rule, there is a limit. President's rule cannot extend beyond 3 years. Ideally not beyond 1 year, but 1 year extension, more than 1 year extension can be if 2 grounds are satisfied. Election Commission of India says we can't hold elections and national emergency is imposed or national emergency is imposed. But in case of financial emergency, once it is imposed and approved by both houses of the parliament by simple majority within 2 months, it continues for an indefinite period unless and until it is revoked by the president. Unless and until it is revoked by the president. Clear? Question 32. Rajya Sabha and Lok Sabha have equal role in passing constitutional amendment bills. To resolve a deadlock on a financial bill, the President shall convene a joint sitting of the two houses of the Parliament. Rajya Sabha alone has the power to create a new All India service. Except the National Capital Territory of Delhi, no other union territory is represented in the Rajya Sabha. Which of these statements is or are incorrect? You have 1 minute. Let me know what is the right answer. President's rule can be proclaimed under Article 365. Correct. President's rule can be proclaimed only under Article 356. But the basis of that can be Article 365. Because under Article 365, directions are issued by the center to the states. If these directions are neglected by the states, it can be viewed that there is breakdown of constitutional machinery, and then under Article 356, President's rule can be imposed. Sunidhi Roy, that is what I was telling, difference between 356 and 365. 356 is for the imposition of President's rule. 365 is directives are sent by the center to the state, and those directives are binding on the state. For example, directives such as you have to ensure means of national importance are upheld, national highways are not blocked, schemes for scheduled tribes are enacted, instruction in mother tongue is given to children of linguistic minorities. Rajya Sabha and Lok Sabha have equal role in passing constitutional amendment bills. This is correct. Because a constitutional amendment bill shall have to be passed by both houses of the Indian Parliament separately by special majority. There is no concept of a joint sitting when it comes to a constitutional amendment bill, because joint sitting is viewed as an inferior role of Rajya Sabha. Because in a joint sitting, the numerical majority of Lok Sabha prevails over Rajya Sabha. Lok Sabha has more members as compared to Rajya Sabha. That is why we say this concept of joint sitting is like an affront to Rajya Sabha. To resolve a deadlock on a financial bill, the President shall. Shall means it is binding on the President to convene a joint sitting. The President may convene a joint sitting, not the President shall. So that makes statement 2 incorrect. Rajya Sabha alone has the power to create a new All India service. Incorrect. Who can create a new All India service? Parliament. But yes, Rajya Sabha has to first approve or allow Parliament to create a new All India service, because Rajya Sabha will pass a resolution by special majority under Article 312. But who can create a new All India service? That power is with the Parliament. Except NCT Delhi, no other union territory is represented in Rajya Sabha. Puducherry is. J&K was, because now since there is no legislative assembly in 2019, when the special status of Jammu and Kashmir was revoked, and then Jammu and Kashmir was downgraded to 2 union territories, J&K and Ladakh. J&K will have a legislative assembly, Ladakh will not have a legislative assembly. What would happen, or what happened to those Rajya Sabha MPs from J&K who were there in Rajya Sabha? They were deemed to be the union territory MPs from Jammu and Kashmir. So they had Rajya Sabha MPs. So Jammu and Kashmir will have, Puducherry has. Incorrect. Question is asking which of these statements are incorrect. C is the right answer. How many gave C as the right answer?
25.
25%. Okay. Question number 33. Which of the following is not a function of the Election Commission of India? In case of ordinary bill, President shall or may convene joint sitting. The President may convene joint sitting. It's not mandatory for the President to convene joint sitting. In case of financial bill, how deadlock gets resolved if President does not call the joint sitting? The financial bill will not be approved, will not pass. That's it. Which of the following is not the function of the Election Commission of India? Preparation of electoral rolls, it is a function. Approving the election manifesto of a political party, it is not a function. Recommending disqualification of a legislator on the grounds of defection under the 10th schedule, it is not a function, because that's the power with the speaker. Where is Election Commission of India used? In recommending disqualification. It is used in recommending disqualification, but if you are disqualified on the grounds of office of profit, change in the nature of citizenship, if you are adjudged insolvent, if you are declared mentally unsound, if a legislator is holding office of profit, is mentally unsound, his citizenship status has changed, he was an Indian, now he is not an Indian, or he has been declared bankrupt. In all these cases, the president can disqualify an MP. The governor can disqualify a member of the state legislature. But president and the governor cannot disqualify them on their own. They have to refer this matter to the Election Commission of India. And the report of the Election Commission of India is binding on the president and the governor. It's another matter. Shri Hemant Soren, when he was the Chief Minister of Jharkhand, it was alleged that he is holding an office of profit. BJP raised this matter went to the governor said, I can't do anything because I have to refer this matter to Election Commission of India. And the governor referred this matter to Election Commission of India. Election Commission of India gave its report, but governor did not act on that report. According to media reports, the Election Commission had recommended that Hemant Soren should be disqualified. But governor did not act on that report. And that governor, Mr. Ramesh Bais, was later on transferred to Maharashtra. So what is mentioned in the constitution and what is exactly happening, that may not always be in sync with each other. Recommending disqualification of legislator on the grounds of defection under the 10th schedule, that's not true. Allotting symbols to political party, that comes under the symbols order. This is correct. Resolving disputes around election symbols and name when there is a split in a political party, that's also correct. We have discussed that yesterday, when there is a split in a recognized political party. Ensuring inner party democracy within a political party, is that a role of Election Commission? Yes, no, maybe. Is that a role of the Election Commission? No, it is. Because Election Commission has to ensure periodic elections in political parties. Otherwise, ECI will take action against them. So which of the following is not the function? 2 is not, 3 is not, so B, only 2 is the right answer. And 39% students were right. Very good. Great. We have very few questions left now, so don't worry, we won't take a lot of time. But how many questions, I will not say. Question 34. The salary and allowances of the Chief Election Commissioner is charged on the Consolidated Fund of India. While a recognized political party can have 40 star campaigners, the registered political parties are allowed to choose only 20 star campaigners during election propaganda. Which of the statements given above is or are? Raftar Singh, sir, statement 5 is incorrect. It does not say recognized political party. It does not also say registered political party. So treat it correct. The salary allowances of Chief Election Commissioner is charged on the Consolidated Fund of India. It's incorrect because that's not charged on the Consolidated Fund of India. President's salary, Rajya Sabha chairperson, Deputy Chairperson of Rajya Sabha, Speaker of Lok Sabha, Deputy Speaker of Lok Sabha, UPSC Chairperson, Chief Comptroller and the Auditor-General, their salaries are charged on the Consolidated Fund of India, which means not subject to vote of Lok Sabha. But can charged expenditure be discussed in Parliament during budget? Yes. Statement number 2 is correct. Question is asking which of the statements are incorrect. A, only 1 is the right answer. How many students gave it correct? 31% only. Don't worry. Star campaigner is, for example, I am from BJP contesting elections from Amethi constituency. I am Smriti Irani. I have a limit. I cannot spend more than 90 lakhs on election campaign. But what if Mr. Modi, who is a star campaigner, he comes to attend my rally or address my rally? Clear? Then I would have spent 90 lakhs on Prime Minister's visit. Chopper, boarding, lodging, security, detail. Clear? Then what would I spend for other days? That's why we have a concept of star campaigner. That means if a star campaigner addresses my election rally, expenditure related to that star campaigner will not be added to my expenditure. Clear? But for that there are certain guidelines as well. When Mr. Modi comes, he cannot ask people to vote for me. He has to generally ask voters to vote for political party, not for this candidate. If Mr. Modi tells people that you vote for Smriti Irani, every expenditure related to Mr. Modi's visit will be added to Smriti Irani's expenditure. And Ms. Smriti Irani will not have to share the days with the Prime Minister. If she does, then every expense of Prime Minister will be added to the expense of Ms. Smriti Irani. Actors can also be star campaigners. So it is not necessary that only party members should be star campaigners. ECI can revoke appointment of star campaigner, yes, if they have violated model code of conduct. Clear? So A only, 1 only A is the right answer. Question 35. Sir, can union downgrade states to UTs without constitutional amendment? Ask yourself, my dear, what do you think is the right answer? This union government did, Parliament did, downgraded Jammu and Kashmir from a state to a union territory, and for that constitution was not amended. The Delimitation Commission is a constitutional body. Sir, how 1 is incorrect? Because salary and allowance of Chief Election Commissioner is not charged on the Consolidated Fund of India. The Delimitation Commission is a constitutional body. The award given by the Delimitation Commission cannot be challenged in any court of law. In India, Delimitation Commission has been set up 4 times since the enactment of the Constitution. Only a Delimitation Commission can be tasked with redrawing of electoral constituencies in India. Which of the statements is or are correct? Registered political parties can also have star campaigners. Recognized parties have 40, registered parties have 20. The Delimitation Commission is a constitutional body. It is incorrect. It's a statutory body. It's not mentioned in the Constitution. The award given by Delimitation Commission cannot be challenged in any court of law. This is also correct. Limitation. In India, Delimitation Commission has been set up 4 times since the enactment of the Constitution. This is correct. 1952, 1963, 1973, 2002. Correct. Only a Delimitation Commission can be tasked with redrawing of electoral constituencies in India. This is incorrect. Why? Because Election Commission of India can do this. And Election Commission of India did this in case of Assam recently. Clear? So which of the statements given above is or are correct? B. 2 statements only is the right answer. Okay. Question 36. Every national party is allotted a symbol exclusively reserved for its use throughout the country, even in the states where it is not contesting elections. Is the statement correct or incorrect? Why are you after questions? If you want me to go, I will leave now. But those who are getting benefited, let them stay. Currently, only 6 political parties are recognized as national parties. If a candidate belonging only to a national political party dies before the commencement of voting, the election in that constituency is adjourned. What is the right answer? It is as if I leave, then other questions will not be discussed and those questions will not be asked in the exam. Delimitation process in J&K was challenged in the court. Award was not challenged. Process may have been challenged. So the petition before the court was, why single out J&K when in the rest of the country there can be no delimitation till 2026 or after the census of 2031? Why single out J&K? So on that basis it was challenged. It was not challenged that why 6 seats were given to Jammu and only 1 seat was given to Kashmir. No. The very creation of Delimitation Commission for J&K was challenged. But then the Supreme Court said there is a limitation that there can't be delimitation in states. But since J&K is not a state, it's a union territory, for that there can be delimitation. So the award was not challenged. Appropriation bill is the bill that you want to get passed because of which you want to withdraw money from Consolidated Fund of India. That is appropriation bill. Priya Kumari says A is the answer. Trust me. Let's see. Every national party is allotted a symbol exclusively reserved for its use throughout the country, even in states where it is not contesting elections. This is correct. Currently, only 6 political parties are recognized as national political parties. This is also correct. Which are these 6 political parties? The one and only the BJP, the Indian National Congress, Communist Party of India, Marxist. Then we have the Bahujan Samajwadi Party. Then we have the National People's Party in Meghalaya. And then yours truly, Aam Aadmi Party. Clear? If a candidate belonging only to a national political party dies before the commencement of the voting, then the election in that constituency is adjourned. Incorrect. If a candidate belonging to a recognized political party dies, and a recognized political party can be a national political party, can be a state political party as well. That is why it is incorrect. So Priya Kumari was right. A, 1 and 2 is the right answer. %41% students were correct. Good. Question 37. According to the Constitution, no person who has held office as a judge of the Supreme Court shall plead in any court within the territory of India. While a judge of the Supreme Court resigns by submitting the resignation to the President of India, the judge of a High Court resigns by submitting his resignation to the governor of that state. According to the Constitution, when the office of Chief Justice of India is vacant, the duties of the office shall be performed by the senior-most judge of the Supreme Court. Which of the above statements is or are correct? Sir, registered political party candidate dies. Om Shanti. Is dead. Elections will continue. Ayushi says A, Vamsi B. Another Ayushi says A. So today we will not take dinner, we will stay with you, as if you are doing me a favor. Thirty seconds to go. Let me know what's the right answer. And those who haven't yet liked the session, let me know when you like it. According to Constitution, no person who has held office as a judge of the Supreme Court shall plead in any court within the territory of India. This is correct. If I am a High Court judge and I have served in Calcutta, Madras, Karnataka, I cannot plead as an advocate in these 3 state high courts, but I can plead in the Supreme Court, I can plead in any other high court. But a judge of the Supreme Court cannot plead anywhere. But yes, he can go to International Court of Justice and be a judge there. Justice Dalveer Bhandari, who is India's representative to International Court of Justice. Okay. Shivansh Saurav, I have liked it yesterday. You are the same guy? Nahi lena? Yes or no? Okay. When a judge of the Supreme Court resigns, while a judge of the Supreme Court resigns by submitting the resignation to the President of India, the judge of a High Court resigns by submitting his resignation to the governor of the state. That's incorrect, because if you're appointed by the President, you have to submit your resignation to the President as well. Okay? According to the Constitution, when the office of the Chief Justice of India is vacant, the duties shall be performed by the senior-most judge of the Supreme Court. This is incorrect. Why? In this case, President appoints an acting Chief Justice of India. Clear? Do we know who is going to be the Chief Justice of India next, and after that, and after that, and after that? Do we know that sequence? Yes or no? Yes. How? According to the judgments given by the court, second judges, third judges, fourth judges, according to memorandum of procedure, outgoing Chief Justice shall nominate his successor to the President who shall be the senior most judge of the Supreme Court who is fit to hold the office. So if Justice Deepak Misra, when his term was about to get over, he nominated his successor, Justice Ranjan Gogoi. Why? Because Justice Ranjan Gogoi was the senior most judge of the Supreme Court and he was fit to hold the office. When Justice Ranjan Gogoi's term was about to get over, he nominated his successor, Justice Bobde. Justice Bobde's term got over, he nominated his successor, Justice UU Lalit. Justice UU Lalit's term got over, he nominated his successor. Similarly, when Justice Chandrachu's term will get over, he will nominate his successor, and that individual has to be the senior most judge of the Supreme Court who is fit to hold that office. Clear? That is why, yes, the senior most judge becomes the Chief Justice of India, but that is not something which is mentioned in the Constitution. That is something that has evolved in India because of the various judicial judgments. Yes, Justice Sanjeev Khanna. Then, question 38. This is not always followed. This has been followed since the second judge's case. What is vote on account? I will tell you after this question, because now the question is on the screen. Students need to answer this question. The Constitution makes no provision for the appointment of the temporary or acting judges of the Supreme Court. The Constitution allows a retired judge of the Supreme Court or a High Court to be part of the Supreme Court sittings only if the retired judge gives his consent. Which of these statements is or are correct? Ayushi says C, Priyanshu C, Boyuddin A. Knowledge track is not on track. He says B. Resignation by judge is given to the president. That's how a judge of the Calcutta High Court resigned by submitting his resignation to the president, joined the BJP and is now contesting elections. Shiv Kumar is asking if I can help you with Karnataka Public Service Commission. But you are Shiv Kumar. You are the Deputy Chief Minister. Okay. The Constitution makes no provision for the appointment of the temporary or acting judges of the Supreme Court. This is correct. Why? Because Constitution thought it would not be nice to have an acting judge in the Supreme Court. Constitution makes the provision for a ad hoc judge. Ad hoc judge in the sense, for example, in Supreme Court there is a constitution bench case, but we are one short of a judge. In that case, the Chief Justice of India, with the prior approval of President, will ask this sitting judge of a High Court. But this sitting judge of a High Court should be qualified to become a judge of the Supreme Court. So ad hoc judge, not the temporary judge or an acting judge at the Supreme Court, ad hoc judge of the Supreme Court, which means if we need a judge in the Supreme Court, the Chief Justice of India, with the approval of the President, will ask a sitting High Court judge, but the sitting High Court judge should be qualified to be appointed to the Supreme Court, and he or she can be asked to be part of this bench for that period. Ad hoc judge. But even if that judge does not want, you can still be forced to be part of the Constitution bench of the Supreme Court. But Constitution allows a retired judge of the Supreme Court or a High Court to be part of the Supreme Court sittings. Yes, that is true. Only if the retired judge gives his consent. This is also correct. So C, both is the right answer. Which means in case of sitting judge, you don't need consent of that judge. You come, I have taken the approval of the President, be part of this bench. But if you are a retired judge of the Supreme Court or High Court, I will take the permission of the President, but I need your consent as well. Without your consent, I cannot make you part of the Supreme Court sittings. Okay. Somebody was asking, what is vote on account? For example, this is an election year. Clear? What is the financial year? April Fool till 31st March. Right? And then there is something called rule of lapse. What is this rule of lapse? This was another question asked by somebody. If the money in the budget was given to Defense Minister that you spend 20,000 crores in a year, in this financial year, but you have not spent 20,000 crore, you have instead spent 18,000 crore. What will happen to the remaining 2,000 crore? That will go back to the Consolidated Fund of India because that money will lapse. That's rule of lapse. Clear? But the money that you have, you can spend only in this financial year, 1st April to 31st March. Done? This is an election year. So in June, we will have a new government in place. If the budget is passed by the previous government for the entire year, that means till 31st March 2025, which means the next government which will come to power, if it is not the BJP government, what if it is my government? Will I have to follow the policies and programs created by the previous government and follow that for the entire year till March 31st, 2025? No. That is why the outgoing government, it only presents a vote on account, which means it only talks about expenditure. It will only ask Parliament for the money to be spent. It will not raise new taxes. It will not fiddle with the tax regime. It will have nothing to do with the revenue part of the budget. So it will only talk about vote on account, which means money will be given to this government for the next few months till the time we have a new government. And when that new government is formed, that new government will present what is known as the interim budget. Interim budget for the remaining part of the year till March 2025. And then after that, the new government will have its full-fledged budget. Okay? Great. Question 39. The Parliament can empower the Supreme Court to issue writs for any purpose other than fundamental rights. It is said that the law declared by the Supreme Court shall be binding on all courts within the territory of India. This, however, is the innovation of the top court and not explicitly mentioned in the Constitution. Which of the above statements is or are correct? Sir, ordinance can be issued when either Lok Sabha or Rajya Sabha will not be in session, but for parliamentary approval is required. Who will give the approval when parliament is not in session? President will promulgate an ordinance when either Lok Sabha or Rajya Sabha or both, they are not in session. And then that ordinance will continue. Now parliament is convened. Now Lok Sabha is convened. Rajya Sabha is convened. Now this parliament has 6 weeks to replace that ordinance with a law. If parliament is unable to replace that ordinance with a law, the law will lapse 6 months after the reconvening of the parliament. That's why we say the maximum validity of an ordinance is 7.5 months. Salaries of allowances of CSE is same as that of the Supreme Court judge? Yes. Okay, the Parliament can empower the Supreme Court to issue writs for any purpose other than fundamental rights. This is correct. It's the Parliament who has the power to enlarge the jurisdiction of the Supreme Court. It is said that the law declared by Supreme Court shall be binding on all courts within the territory of India. This is an innovation of the top court and not explicitly mentioned in the Constitution. This is incorrect. This is explicitly mentioned in the Constitution. Where? Article 141. So which of the above statements is or are correct? A, only one is the right answer. What is the status of opinion poll and exit poll? What is the status of right to vote? Right to vote is a constitutional right. Collegium system will not work in case of question number 37. What is question number 37? According to when the office of Chief Justice of India is vacant. Vacant in the sense Chief Justice of India dies. Chief Justice of India is removed. Chief Justice of India resigns. In that case, who will be the Chief Justice of India? Somebody appointed by the President. When the Chief Justice of India's term is about to get over, then the President is given recommendation by the outgoing Chief Justice that you nominate, I am nominating him to the post of Chief Justice of India. What if in absence of that nomination, there is a vacancy? Then the President will appoint. Right to vote is a constitutional right under Article 326 of the Constitution, although it is also mentioned under Representation of the People Act 1951. What is the status of opinion poll? What is the status of exit poll? Exit poll banned in India. During elections. Can be published or broadcast after voting is over. In all phases. In case of multi-phase election. So exit polls are banned in India, which means during voting, during election campaigning, you cannot publish or broadcast the findings of the exit poll. Exit poll findings can be broadcast only after the last person has cast his or her vote. Which means if it's a multi-phase election, when the last 7th phase will be over of Lok Sabha election, then when the last person has cast the vote, then you can publish and broadcast the findings of exit poll. There is no such ban on opinion polls. But the only thing is, cannot be published or broadcast during the period of election silence. What is that election silence? If the voting ends tomorrow at 6 p.m., tomorrow is Monday, 6th of May, 6 p.m., the voting ends. From that time, reverse 48 hours, go back 48 hours. That is the period of election silence. And during this period, you cannot broadcast or publish the findings of opinion poll. That's the regulation on opinion poll. But exit poll, there is a ban. Suicide is not a right, guys. Suicide is not a right. The opinion of the Supreme Court under Article 143 is not binding on the President. The Supreme Court has no jurisdiction in the matters related to interstate river water disputes. Which of these statements is or are correct? Right to vote is not a constitutional right. Right to be part of the electoral. Right to vote, Supreme Court has said, is a constitutional right under Article 326. In fact, it is also part of the official answer key released by UPSC. Now, this statement, question number 39, statement 1, the Parliament can empower the Supreme Court to issue writs for any other purpose other than fundamental rights. This is correct. Because just like High Courts can issue writs for legal rights as well, the same jurisdiction can be enlarged for the Supreme Court. The Parliament can empower Supreme Court to issue writs for statutory rights as well. The opinion of the Supreme Court under Article 143 is not binding on the President. This is correct, because that is only an advisory jurisdiction of the court. It is not binding. But then later on, technically it becomes binding, because what if the government ignores that advice and then passes a law ignoring the advice of the Supreme Court? So when that law will be challenged before the court will strike down that law, because that law is unconstitutional, not because you are violating our advice, because advice is not binding on the President. The Supreme Court has no jurisdiction in matters related to interstate river water disputes. Incorrect. Which of the statement is correct? A, only one is the right answer. Supreme Court has no original jurisdiction. That means you can't directly file a dispute related to interstate river water in the Supreme Court. It has to go to a tribunal, Interstate River Water Disputes Tribunal. And the award of that tribunal can be challenged before the court. So which means the Supreme Court can have appellate jurisdiction. If the statement would have mentioned Supreme Court does not enjoy original jurisdiction in interstate river water disputes, then that statement is correct. But if the statement is saying the Supreme Court has no jurisdiction whatsoever, then this is not correct. So question number 40A, one only is the right answer. Is that clear? Okay. Question number 41. The salary of the CAG is charged on the Consolidated Fund of India. The Constitution does not mention subscribing to an oath for a citizen appointed as the CAG. The CAG is ineligible for further office either under the Government of India or Government of any state after he has ceased to hold his office. A retired IAS officer cannot be appointed as the CAG. How many statements given above is or are correct? These questions are not previous year's question papers. Ayushi says B, AAT Academy. Only one. What is the role of NJAC in appointment of judges of High Court and Supreme Court? There is no role because 99th Constitutional Amendment enacted NJAC, but that was declared unconstitutional by the Supreme Court, so NJAC has no role whatsoever. Salary of CAG is charged on the Consolidated Fund of India, correct? The Constitution does not mention subscribing to an oath. This is incorrect. Why? Because the oath of a CAG is mentioned where? Schedule 3 of the Constitution. CAG is ineligible for further office either under the Government of India or Government of any state after he has ceased to hold office. This is correct. This is to protect the independence of this office. A retired officer, IAS officer, cannot be appointed as the CAG. This is incorrect because we have a retired IAS officer as the CAG right now, Mr. Murmu. So which of the statements are correct? 2B is the right answer. Question number 42. Which of the following is not the discretionary power of the governor? You have 1 minute. Answer this question. Reserving a bill for the consideration of the president, recommending president's rule in his state, reserving a bill which threatens the powers of the High Court to the president, sending fortnightly reports to the president, highlighting important developments that have taken place in the administration of the state. If UPSC asks question as to right to vote as a constitutional as well as statutory right, so the explanation is right to vote is a constitutional right. Sir, to suspend Lok Sabha MPs, do the approval of the House is needed? Approval of the House is needed, but there is also an automatic suspension, where if the Speaker names a member who has come to the well of the House, who is raising slogans, who is shouting, and the moment Speaker names that member is automatically suspended. Reserving a bill for the consideration of the president, it is a discretionary power. Recommending president's rule in a state, it is a discretionary power. What is a discretionary power? Where the governor is acting without the aid and advice of the Chief Minister and Council of Ministers. So even if the Chief Minister is not advising the governor can reserve a money bill to the president. The governor can recommend president's rule. The governor can send, and the governor does send fortnightly reports to the president, informing the president how the administration is being carried out. The governor can reserve any bill for the consideration of the president. And reserving any bill for the consideration of the president is a discretionary power of the governor. That's how there is a tussle between the governors and the chief ministers, particularly in opposition-ruled states. States such as Kerala, Telangana, Punjab. Now you would see that in Karnataka as well. Tamil Nadu is a big example. But if there is a bill passed by the state legislature, and that bill threatens the powers or the jurisdiction of a high court, the governor has to necessarily reserve that bill for the consideration of the president. So that is not the discretion of the governor. That is mandatory for the governor. Clear? So the question is asking which of the following is not a discretionary power. 3 are discretionary. 3 is not. 3 other statements are discretionary. 1, 2, 3. 1, 2, 4. They are discretionary. 3 is not. So A, only 1 is the right answer. Clear? 32% Janta is right. Last few questions left. So we are towards the end of the session. Which of the following were added to the Constitution or are the consequences of the 42nd Constitutional Amendment Act 1976? Fundamental duties, advice of the Prime Minister, Council of Ministers binding on the President, provision for administrative tribunals, creation of all India Judicial Service. If a law is passed by the Parliament to be inserted in 9th schedule, does it require amendment to the Constitution under Article 368? It requires a parliamentary law. Under Article 200, a law proposed by state legislature is not extinguished after refusal by the governor to give his assent. Yes, which means the Supreme Court clubbed absolute veto and suspensive veto together. Previously, we thought that it was, not just that we thought, that when a bill is sent to the governor for assent and the governor withholds his assent, saying, publicly declaring that I'm not going to sign this bill, that's what we call the absolute veto. That was viewed as the death of the bill. It will never become a law. But now the Supreme Court has said in case of Punjab that when a bill is sent to the governor and the governor withholds his assent, that does not mean that this bill will extinguish, will disappear, will be the death of this bill. You have to immediately send this bill back to the state legislature. And then if the state legislature enacts that same bill again, it's binding on you to give your assent because we are in a parliamentary democracy. Okay? 42nd Constitutional Amendment Act inserted fundamental duties, 10 fundamental duties. 11th fundamental duty was added by the 86th Constitutional Amendment Act 2002. So total we have 11 fundamental duties. Advice of the Prime Minister and Council of Ministers is binding on the President. This is how Article 74 was amended. There shall be Council of Ministers with Prime Minister at its head to aid and advise the governor. Only this was mentioned in Article 74 prior to 42nd Amendment. After 42nd Amendment, it read, who shall act on that advice? So there shall be Council of Ministers with Prime Minister at its head to aid and advise the governor who shall act on that advice. So making the advice of Council of Ministers and the Prime Minister binding on the President. Correct. Provision of administrative tribunals. That's how Article 323A and B were enacted during emergency. Creation of All India Service. All India Service has been created, but it has not been notified yet. And Constitution says that every post in All India Service should be not less than that of a district judge. Select the correct code from below. D, all the 4 statements are correct. Done? Question number 44. A same person can be appointed, not a sane person. Then the statement would have been incorrect. A same person can be appointed as the governor of maximum 2 states or union territories. The legislature of a state can confer executive functions on any authority subordinate to the governor. The tenure of the governor is not mentioned in the Constitution. Which of the above statements is or are correct? You have got 1 minute. Let me know what is the right answer. Lock it A, then it is wrong. A same person And I'll repeat that joke again, which most of you did not understand. It's not a sane person, then the statement is wrong. A sane person, and I think majority did not understand either. But be that as it may, okay. A same person can be appointed as the governor of maximum 2 states or union territories. This is incorrect. Why? Because 7th Constitutional Amendment Act 1956, it allows that a person, same person can be appointed as the governor of 2 or more states. The legislature of a state can confer executive functions on any authority subordinate to the governor. Correct. In fact, not just legislature, even the parliament can confer executive functions on any authority which is subordinate to the governor. The tenure of the governor is not mentioned in the constitution. Incorrect. It is mentioned in the constitution that the tenure of the governor is 5 years, but that is subject to pleasure of the president. So which of the statements given above are correct? A, only one is the right answer. How many students? 23%. Okay. Now finally, a relief for all of you, or for some of you. This is the last question. Question number 45, the last question for today. After that, whatever doubts you have, I'll take another 10 minutes and resolve your doubts, whatever you have. So we started at 7:30. We will end the session at 10:30, so a 3-hour session. And the intention was, the hope was to cover lots and lots of static topics, concepts that you can find helpful when you approach the prelims exam. Why right to vote is a constitutional right? Ask the Supreme Court, because they have ruled right to vote is a constitutional right. A member of either house of the parliament or of a house of the legislature of any state shall have to resign before taking oath as the governor of the state. If the same person is appointed as the governor of 2 states, then the salary of the governor shall be charged on the Consolidated Fund of India. The governor takes the oath to defend the Constitution. What's the right answer? Sir, I will vote for you if you contest Lok Sabha election. Then you should tell me from which constituency should I contest, where you are a voter. Sir, please teach important topics for Prelims 2024 on platform or YouTube. What are we doing here? These are not important. Chikmagalur, where Indira Gandhi once contested. Okay. A member of either House of Parliament or a House of the Legislature of any state shall have to resign before taking oath as the governor of a state. This is incorrect. Because if a member of a house or a member of a parliament or member of the state legislature is appointed as the governor, then when the governor takes oath, it is assumed that you have resigned from your seat. So you don't have to necessarily resign before taking oath. Once you take oath, you have resigned. If the same person, again, not the same person, if the same person is appointed as the governor of 2 states, then the salary of the governor shall be charged on the Consolidated Fund of India. Incorrect. Why? The president will decide the split. whether it is 50-50 on consolidated fund of those two states or what. The governor takes oath to defend the constitution. Yes, he does. But whether they live up to that oath or not, that's an open question, but they do take oath to defend the constitution. Which of the given statements is or are correct? A, only one is the right answer. 42%. That is it for today in this session. A marathon. Marathon, normally people say it should be 8-hour, 10-hour session. But this is a marathon, a 3-hour stretched class without a break on some of the important topics that can be relevant for your upcoming prelims. All we need is your blessings. And that's what we need. And you needed last-minute revision. That's what you got. And if you have enjoyed the session, in a sense, if this was of some benefit to you, once the live session is over, please drop in comments in the comment section so that it encourages us. And if you have understood this, please press the like button and share the links of these sessions with your friends and fellow aspirants. And if you haven't yet, then do subscribe to our YouTube channel. Any questions further, please let me know. Another 5-7 minutes till 10:30. Parole is at the discretion of the prison authorities. Furlough is the right of a prisoner. What about tomorrow's class? Tomorrow, international relations-based current affairs will be discussed 7:30 p.m. onwards. Chetan sir would be taking those sessions. From where is CSE salary paid? From Consolidated Fund of India, but it is not charged. It's expenditure made on the Consolidated Fund of India. What is this facility to vote through proxy introduced? Can you pause that comment? No, there was a comment on proxy. Okay, here. So these are mentioned in election conduct rules, not in the Representation of the People Act. And those rules talk about absentee voters. For example, if you are a senior citizen, if you have been infected with COVID, if you are a service voter, if you are in the service, all these are eligible, become entitled to vote through postal ballot. Who takes an oath to defend the Constitution apart from governor? It's the president. I am pursuing PhD in commerce. Can I still study full-time? Can I still prepare for the civil service exam? Why can't you? Yes, you can. Inputs on PSI are optional. Maybe we'll have a separate discussion on that, and PSI are optional is for mains. We're talking about prelims right now. Oath of the Supreme Court judge is also mentioned in Schedule 3 of the Constitution. Status of right to property. Right to property is a legal right, constitutional right under Article 300 capital A. Sir, you said EC cannot file an FIR, but it can direct the law enforcement agency to take action if MCC is violated, as an AP FIR is filed against Chandrababu Naidu for fake propaganda about Land Tilling Act. There are some provisions in Model Code of Conduct which are covered under IPC, which are covered under, let's say, Representation of the People Act. For example, an FIR was filed against the student who is attending this class right now, Mr. Shivkumar, the Deputy Chief Minister of Karnataka. Why? Newspaper said FIR filed against DK Shivkumar for violating Model Code of Conduct. But that was not for violating Model Code of Conduct. That was for bribery, because he tried to bribe voters, which is a criminal offense under Representation of the People Act. So you can't file an FIR for violating Model Code of Conduct because that's not a law. But there are some provisions of MCC which are prohibited under other laws. For example, the Representation of the People Act. For example, Indian Penal Code. How to deal with insecurity of failure? Be secure that you will succeed. Difference between constitutional rights and legal rights, and what is sub judice. A matter which is pending before the court, we call it sub judice. For example, is CAA sub judice matter? Yes, it is, because the matter is with the court. Mr. Kejriwal is in the jail. It's a sub judice matter involving PMLA. All those rights which are provided by law, they become legal rights. Now, one law can be supreme law of land, and that supreme law of land is constitution. So all those rights which are mentioned in the constitution are constitutional rights. But all the rights which are provided by another law, let's say the law passed by the parliament, they are what we call statutory rights. For example, freedom of speech and expression is a constitutional right, fundamental right. A right to vote is a constitutional right provided by the Constitution. A right to interstate trade and commerce is a constitutional right provided by the Constitution. And what is Constitution? It is a supreme law of land, but it is a law. So even constitutional rights are legal rights. Fundamental rights are legal rights. But there are rights which are given by the law passed by the parliament. For example, you have a right under MG Narega. That is a statutory right. A right to seek information from a public body, that's a statutory right under Right to Information Act 2005. So not all statutory rights are constitutional rights. All constitutional rights are legal rights. But all legal rights are not constitutional rights, because some legal rights are given by the parliament, by the statutes. My friend secured 500 rank in UPSC CSE 2023, but he say he didn't join service. Is it good or bad? That is an individual decision. Who are we to judge whether the decision is good or bad? We should not be judgmental. That's for the individual to decide. How Rajya Sabha constituency area is defined? I mean, who will vote? There is no constituency in a Rajya Sabha election. From a particular state, we will have some MPs. That has been decided. And all the MLAs from that state will vote. Types of grants, for example, you have supplementary grant. Budget was passed, your ministry was given 1,000 crore for spending in the entire financial year, but you exhausted 1,000 crore in the 10th month. Then what will you spend in the next 2 months? For that, you will ask for supplementary grants. Please supplement the amount of money that you gave me before. For that, supplementary grant has to be passed. And there are other grants as well. Token grant. Right to marry is a constitutional right. Right to marry is not a fundamental right. It's not a constitutional right. Okay, that is it for today. Thank you so much for staying with me. It's 10:30. Have a great time. All the best. Be confident. Stay safe. Stay best. You have done well. You will do good. Be confident when you are reading the questions and when you are filling the OMR sheet. Thank you so much for staying with me. We'll see you soon with lots and lots of good initiatives for the welfare of the students. Bye-bye. Take care. Good night. And I will wait for your comments in the comment section. Bye-bye. Good night. Take care.